Good morning. Well, it looks like we have got most people now having joined us. So welcome everybody to our 7th annual set of Nugee pension lectures. Today marks the first of 4 lectures this year. And in this session, we will be hearing first from Edward Sawyer and Simon Atkinson, who will tell us about the latest on recovery of overpayments and equitable set-off in statutory schemes. Then I'm going to hand over to Andrew QC and Tom Robinson, who are going to cover the effect of limitation periods on claims for benefit underpayments following Lloyds and Axminster. We are very keen that today should be interactive and we're going to welcome your contributions. We would very much like it if you could use the Q&A button at the bottom right-hand side of your screens rather than the chat function. If you've got any questions throughout the session, and we will pick those questions up, first of all in relation to Edward and Simon's talk at the close of their talk, and then after Andrew and Tom's talk. And if there are any additional questions thereafter, we'll try to pick them all up before the close of this session. And rest assured, you can ask those questions anonymously if you would prefer. So on that note, I think it leaves me to hand over first of all to Edward Sawyer and Simon Atkinson.
Well, good morning, everyone, and may I add my welcome to you all. I'm just going to share my screen, some slides. So Edward and I are going to be considering some of the issues which arise when pension payments are or may have been overpaid. We want to look at some of the legal and practical issues which might arise, and we're going to consider some of the recent developments in this area, such as limitation issues in the proper scope of Section 91 of the Pensions Act 1995. Now, just to set the scene, I'm going to consider some of the claims and defences which are frequently encountered in this area before moving on to consider the particular issues of limitation and recoupment. And then Edward's going to be considering the defence of equitable set-off and the extent to which Section 91 may or may not preclude a claim for recovery for overpayments, before we turn then to consider some of the practicalities which trustees or members may have to grapple with. So quickly, by way of background, let's just remind ourselves of the context in which we meet pension overpayments. Now, of course, the starting point, as we all know, is a member only has a right to benefits as set out in the trustee rules or other instruments such as regulations which govern the pension scheme, and the trustees have a duty to manage the scheme in accordance with those rules and the general law. So where a member has been paid a sum to which he or she is not entitled under the rules, then in principle a trustee or administrator should be able to recover such overpayments. Now, when they've been paid mistakenly, then it's likely that there will be a claim in unjust enrichment to recover the overpaid sums, the unjust factor, of course, being a mistake of fact or law. And that applies equally to private pension schemes as to public sector pension schemes. And the sort of mistakes that we come across quite frequently at the moment are where trustees or administrators have miscalculated pensionable earnings in relation to certain classes of member. And we also quite often see claims where trustees have miscalculated lump sum entitlements and so forth, and have sought to reclaim the amounts that have been overpaid. An important point to remember is that even if the error has been caused by the negligence of the administrator, that doesn't necessarily preclude a claim in unjust enrichment. But if the administrator had suspicions at the time of the payment that the member might not have been entitled to it, then that might, depending on the facts, preclude a claim. There's also the potential, obviously, for an alternative claim for proprietary relief, but of course that's rare in practice because you have to be able to identify the traceable proceeds or the payment itself, and of course that's rare in practice. The sorts of defences that we see, as you know, are the usual suspects here: change of position, estoppel and contract. Change of position, of course, is the one that's most frequently encountered and successful if the recipient can show that he or she is so changed position that it'd be inequitable for them to be required to repay sums, then they won't be required to do so. And of course, the classic case, not very prevalent at present, I expect, is the person who takes an extravagant holiday on the basis of a higher pension payment that he otherwise would not have taken. Now, while the recipient has to have acted in good faith, negligence won't be a bar to invoking that defence. but the defence, of course, is only pro tanto. The court can still order partial repayment as long as it wouldn't be inequitable for the recipient to have to do that to that extent. Estoppel, as we know, is often pleaded but rarely successful. And the problem here is, of course, you have to have an unambiguous representation by the trustee or the administrator that the recipient is entitled to the payment, or there must be a shared similar assumption to that effect. And of course, the payment itself is not normally such a representation. And the problem frequently encountered in practice, of course, is that members are told to refer to the trust deed and rules or the regulations, which set out clearly, usually, what they're entitled to. So there isn't an unambiguous representation. And we sometimes see contracts being pleaded, but that's very fact dependent, where a member can show that there was a binding agreement supported by consideration to the effect that he or she was entitled to an overpayment, then that will be a good and complete defence to a claim. But it's obviously rare in practice to come across facts of to support such an agreement. But now let's turn to some of the more interesting and complex, nuanced defences which might arise in some cases, and they concern, for the purposes of my part of the talk, limitation and certain equitable principles. So dealing with limitation first. Oh, hang on, that skipped ahead. There we are. Hang on. My slides are playing up. Hopefully you can see the limitation slide. Now, it's well established that a claim in unjust enrichment to recover a mistaken overpayment is 6 years from the date of payment. And there's some authority there which has cited the relevant case law at paragraph 25. It's based by application on Section 5 of the Limitation Act. It's assumed that, and stated that an unjust enrichment claim is an action founded upon a simple contract, and there's a high authority for that proposition. It has been assumed in the case law that each individual payment or overpayment of a pension instalment gives rise to a separate claim to recover the overpaid element. And that was stated in the Weber case, although, again, the parties just proceeded on the basis that was correct. It wasn't actually decided, but that certainly seems right to me. One of the interesting questions which does arise when we're dealing with overpayments is whether a trustee or administrator could try to invoke essentially a longer period by saying that the limitation period, the start of the limitation period, should be postponed by virtue of Section 32 of the Act. As we know, that provides certain not pausing, but it prevents time starting to run where there's been fraud or in relevant for our case, a mistake. The limitation period will be postponed and will only start to run once the plaintiff or the claimant has discovered the mistake, or could with reasonable diligence have discovered it. And the question which arises then is, well, can a trustee or administrator who may have made an error say, well, I should be able to go back more than 6 years because I couldn't with reasonable diligence have discovered the error? Well, where the mistake has resulted from administrative errors by the trustee or the administrator, I think it would be difficult for the trustee to show that it could not, with reasonable diligence, have discovered the fact that the payments were being made in error. It's obviously a very fact-dependent question. The trustee might say, well, you know, we were relying on information from the employer, for example, in the context of pensionable earnings information, or perhaps from the employee or his family, where overpayments have been made as a result of a failure to provide up-to-date information, for example, about marriage status, perhaps. And so the trustee might be able to say, well, you know, I was relying on other information. I couldn't have, with reasonable diligence, have discovered that error. But where we simply have an administrative error made by the trustee, the administrator, some error that is just in-house, as it were, I think at the very least it would look unattractive for the trustee to say that the time period for limitation should be postponed for a period. But that is an issue which does come up quite frequently in this area and can be a source of some argument. So do watch out for this, the Section 32 point when trustees are trying to go back more than 6 years. The second interesting response that trustees might make in the context of limitation and trying to get around issues related to limitation. It arises in the context of equitable recoupment. Now, let's suppose that 6 years have elapsed since some of the overpayments that have been made, and the trustee is unsuccessful in arguing for a delayed start to the limitation period under Section 32. Are there any other workarounds for them? There might be, and this is one of them. So equitable recoupment, as we know, permits trustees to recover overpayments from recipients by making deductions from future payments which are to be made to them. Now, it's essentially a self-help remedy, and that was made clear in the Burgess and Bick case at first instance. It's not a restitutionary claim, it's a self-help remedy, and its origins lie in the administration of trusts and estates, where a recipient, a beneficiary, has received more than he or she is entitled to. Then the trustee or the administrator is entitled, if there are further payments to be made, to recoup from those future payments the overpaid elements. Simple to state the principle, but there are several particular points to consider. The first of which is, of course, it is an equitable doctrine, which means that it is subject to the defence of late fees, where it would be inequitable for the trustee or the administrator to rely on it. And of course, delay can be a bar to equitable relief. Usually, however, you need to show some sort of equitable reliance by the payee. But of course, you will be thinking about detrimental reliance, delay, that sort of thing in the context of considering estoppel or change of position defences to an unjust enrichment claim. And similar sort of issues may arise in the context of the question of late fees and delay. That's the first one. So the Limitation Act doesn't apply, but late fees does. Second, equitable recoupment is potentially subject to the operation of Section 91. I'm not going to say any more about that, but Edward's going to cover Section 91 in more detail shortly. Thirdly, of course, the rate of recoupment must not be so high as to be inequitable. Now, that's obviously a very fact-dependent question and most obviously depends upon the period of time over which recoupment is sought. Now, the Pensions Ombudsman takes the view that recoupment is permissible where the recovery period is at least as long as the period over which the overpayments were made. But the financial position of the member and the hardship that may arise should be taken into account by the trustee or the administrator. So that's the Pensions Ombudsman's sort of starting point. Obviously, it's a very fact-dependent issue. Lastly, it's probably the case that the doctrine of equitable recoupment doesn't apply in the context of unfunded statutory schemes, such as public sector schemes. And that's because of the origin of this doctrine in trusts and estates. It's a trust doctrine, and statutory schemes are not generally constituted as trusts. And the Pensions Ombudsman took the view in a case of re Mr. E, which Edward is also going to be talking about in more detail in relation to equitable set-off, took the view that equitable recoupment doesn't apply in the context of for example, public sector statutory schemes which are not funded. So if you're a member of such a scheme, it's very probably the case that the administrator can't look to recoup overpayments from future payments. Now, that's all I wanted to talk about in relation to equitable recoupment. And now I'm going to pass over to Edward, who's going to consider some of the other potential defences and issues relating to recovery of overpayments. So over to you, Edward.
Thanks very much, Simon. So in this part of the talk, what I want to look at, first of all, is the recovery of overpayments by a statutory scheme. Secondly, that leads me into looking at the concept of equitable set-off to recover overpayments. And thirdly, I want to look at the recovery of time-barred overpayments, which brings in the impact of Section 91 of the Pensions Act 1995. So turning to the recovery of overpayments by a statutory scheme, as Simon mentioned, a statutory scheme is usually not established as a trust, and you get that from the Scottish case of Re Bain. A statutory scheme can nevertheless still recover mistaken payments by a claim in unjust enrichment. There's clearly no bar to a statutory body administering a public fund from recovering mistaken overpayments in unjust enrichment. And indeed, HM Treasury guidance called Managing Public Money imposes a general obligation on public bodies to recover overpayments, and that guidance is applied by statutory schemes to recover overpaid pensions. The more interesting question is whether the right to recoup overpayments from future benefits applies to a statutory scheme. And some statutory schemes contain provisions expressly providing for the recovery of overpayments. But if the scheme doesn't so provide, does the right of equitable recoupment apply to statutory schemes? And as Simon touched on, equitable recoupment is a trust law doctrine, and so it's open to significant doubt that it could apply to statutory schemes. And as Simon mentioned, last November, the Pensions Ombudsman held that equitable recoupment is inapplicable to a statutory scheme in the case of Mr. E. That concerned the teacher's pension scheme. And in that case, Mr. E was a headmaster who had accidentally been overpaid pension because of an error calculating his final salary. Teachers' pensions sought to recover overpayments by reducing his future pension, and the Ombudsman held that equitable recoupment was inapplicable because it was a statutory unfunded scheme not constituted as a trust. However, he held that equitable set-off could be invoked to recover the overpayments from future benefits. So I turn, therefore, to the concept of equitable set-off. And the principles were recently explained in a case called CIS and IBM, which drew on previous case law. And essentially, equitable set-off allows cross-claims to be deducted from a claim where the cross-claims are so closely connected that it would be inequitable and manifestly unjust to allow the claimant to enforce payment without taking into account the cross-claim. So applying that test in the pension overpayment context, you can see that the test could well be satisfied. The pensioner has a claim for future pension instalments, but the scheme has a cross-claim to recover prior overpayments, and it could well be said it would be manifestly unjust to allow the pensioner to claim his future pension without giving credit for the cross-claim, because otherwise the pensioner will effectively be double dipping at the expense of other members. Now, the advantages of equitable set-off for a scheme are that it's a self-help remedy. It can be relied on outside the litigation process, so there's no need for a court claim. And on the face of it, it applies both to statutory schemes and also to trust schemes. So that gives rise to the question of whether equitable set-off and also equitable recoupment can be used to recover time-barred overpayments. And that's the next topic I want to look at. As Simon has explained, if a scheme brings an action in court to recover overpayments, it's subject to a 6-year limitation period. But as Simon suggested, equitable recoupment is a workaround that permits recovery of time-barred overpayments because it's a self-help remedy not requiring court proceedings. And so, according to the case of Burgess and Bick that Simon mentioned, it's outside the Limitation Act 1980, but subject to the doctrine of laches. And the position seems to be the same under the doctrine of equitable set-off. That's another self-help remedy that doesn't require court proceedings. And as you would expect, the case law confirms that you can use equitable set-off to deduct time-barred cross-claims. And you get that in a case called Phil Ross Securities and Midgley, which I mentioned on the slides. But for equitable set-off, the cases don't seem to suggest that the doctrine of laches applies. So possibly equitable set-off provides a way round a laches defence to equitable recoupment. However, it should be borne in mind that the test for equitable set-off is based on the cross-claims being closely connected. And if the cross-claim itself is stale and time-barred, then you could argue that it's not sufficiently closely connected to the main claim. And there's some support for that proposition in a case called Guidance Investments, mentioned on the slide, which suggests that the close connection test for equitable set-off involves a temporal element. It's debatable whether in the context of a pension scheme, therefore, you can get equitable set-off in respect of time-barred overpayments. There's no case law on that, so that is a point for argument on another occasion. And that brings me finally to Section 91 of the Pensions Act. Even though in principle equitable set-off and equitable recoupment may permit recovery of time-barred overpayments, that could give rise to a problem under Section 91. And as you know, Section 91 provides in subsection 1 that a pension entitlement can't be subject to a charge, lien or set-off as set out on the slide, but that's subject to Section 91(5), and in particular paragraph F, inserted by the Pensions Act 2004, which permits a charge, lien or set-off for the purpose of discharging the member's monetary obligation arising out of a pension payment made in error. But that itself is subject to subsection 6, which limits the amount of charge, lien or set-off and requires a certificate. That's in paragraphs A and B. But importantly, in the closing words, which I've underlined on the slide, it's provided that if there's a dispute as to the amount of the charge, lien or set-off, it mustn't be exercised unless the member's monetary obligation to make a repayment has become enforceable under an order of a competent court. And it seems to me that this could be important in the context of recoupment or set-off of time-barred overpayments, because if Section 91 catches equitable set-off and recoupment, which arguably it does, you couldn't get an order from a competent court making the repayment obligation enforceable. And so if you apply the underlined closing words, if the member disputes the amount due, deductions can't be made unless the member's repayment obligation has become enforceable under an order of a competent court. And how could a court make an order to enforce the monetary obligation if the overpayment is time barred? That would mean you couldn't get a court order. Now, the Ombudsman seems to take a different view. He says that he is a competent court, so if a member refers a complaint to the Ombudsman, he can determine the amount of the overpayment, and this suffices as an order of a competent court. But I suggest for your consideration that that analysis may not be correct, because we know from case law that the Ombudsman is bound to give effect to limitation periods. So the Ombudsman couldn't make a direction to enforce the repayment of a time-barred overpayment. The only basis on which a time-barred overpayment can be recovered is by the self-help remedies of equitable set-off or recoupment. And as they are self-help remedies, the Ombudsman has no role to play in making an order to enforce them. So arguably, therefore, the overall result should be that neither the court nor the Ombudsman could make an order to enforce repayment of a time-barred overpayment. And so if the amount is disputed, the closing words of Section 91(6) can't be satisfied, with the result that Section 91 would prevent any charge, lien or set-off of time-barred overpayments. And that would preclude equitable set-off, which clearly is covered by Section 91, and arguably it might also include equitable recoupment. As Simon touched on, there is potentially a debate as to whether Section 91 does catch equitable recoupment. In Burgess and Bick, it was conceded that Section 91 does catch equitable recoupment, but there may well be a contrary argument to that on the footing that equitable recoupment isn't, in fact, a form of charge, lien or set-off, but merely an accounting mechanism. In any event, I suggest there is an interesting point on Section 91 and recovery of time-barred overpayments, and it will be interesting to see whether any member does eventually appeal to the High Court to challenge the Ombudsman's view that he can make time-barred overpayments recoverable. So that concludes what I wanted to say on the topics that I was going to address today. At this point, I was going to bring Simon back in just to have a brief discussion between us about some of the practical implications of all of this. And a point which I wanted to raise on the practical front is whether it's actually ever sensible for a member to complain to the Ombudsman about the recovery of time-barred overpayments. Because if a member brings an Ombudsman complaint, that just opens the door to the Ombudsman saying that he's a competent court who can order recovery, thus satisfying section 91(6). And I wonder whether a member might be better off simply sitting tight and doing nothing and wait to see if the trustee brings a claim in court. And if the trustee does bring a claim in court, then it can be defeated on limitation grounds. So this may be a rare instance where the member is actually better off not bringing a complaint to the Ombudsman, but waiting for court proceedings. Simon, I don't know if you have any thoughts on that, or whether there are any other practical points you want to address arising out of what we've been talking about this morning.
Yes, I suppose just on that point, Edward, if the member did bring a complaint and there was then a dispute before the Ombudsman regarding section 91F, then I suppose it would be open to the member, if unsatisfied by the Ombudsman's decision, to seek permission to appeal on a point of law on that point. Although, of course, I'm not sure a member would necessarily be excited at the prospect of having to go all the way to court to resolve this point with the cost risk that would entail. But allied to that practical point, and whether the trustees whether a member should just sit tight, I suppose that consideration may well be influenced by whether a trustee or administrator is going to is likely to bring proceedings to recover an overpayment, and that raises in my mind the question of whether a trustee or administrator is under an obligation to seek to recover overpayments. Whether there's a duty to do so on the trustee or the administrator, or whether it's just a sort of discretion. And I think it was I don't know whether it was conceded or maybe it was just a passing comment from the judge at first instance in Burgess and Bick, seemed to suggest that trustees were under a duty, a positive obligation to seek to recover overpayments. And it struck me that that's not obviously right, although obviously, if there's been an overpayment made, then presumably it is possible that, that there may be claims against the trustees for having done that, and they may be conscious of that, and that may encourage them to try to seek overpayment. But it strikes me it's more naturally the case that it would be a discretionary decision for the trustees, bearing in mind their general duties regarding administration of trusts and the various considerations that would go into the question of whether they should bring a claim or not. I don't know, Edward, whether you have any thoughts on whether you think it's the trustees are obliged to, or administrators are obliged to, or whether they just have discretion to bring proceedings.
Well, I think there are cases that suggest that it's a discretion. Like Capita and Galately suggests it's a discretion and the trustees don't have to seek to recover overpayments. But I wonder whether that's actually right, because if you adopt the recoupment analysis, the member has actually already received the benefit payment. It's just treated as an advance payment. And on that basis, you might say, well, the trustee is obliged to make the deduction because he can't pay the same benefit twice, and it would be a breach of trust if you pay the benefit again. So I think there's an unresolved tension in the case law on that point. It's quite an interesting point.
Yeah.
Well, I think possibly we are reaching the end of our allotted time. So at this stage, I will hand back to Emily. There may be some questions that have come in from the audience, but I'll hand back to Emily to see whether we have time to deal with any of those.
Thank you very much to both of you for that. We've got a couple of questions and I think an observation. The first question comes from Lauren Cathro, who asks, in connection with your discussion about section 91(6), what would count as a dispute for the purposes of section 91? Would there have to be an outward expression of disagreement? Would a failure to respond to letters be enough?
Well, perhaps I could come in on that. Well, that is an interesting question. I'm not aware in the case law that there's any specific guidance on that. I would be inclined to think that there would have to be some kind of outward manifestation, or at least the member querying the amount and saying it's not accepted. So if there is complete silence from the member, I tend to think that wouldn't qualify as a dispute, because the member hasn't actually challenged anything. No issue has been joined. there's just silence. So to get the section 91.6 off the ground, a member, I think, would be well advised to at least write a letter challenging the amounts, which I have to say, in most cases, I would expect a member could challenge the amounts, because generally members won't have a clue precisely what the right amount will be. And so all they would have to do is write a letter saying, well, I don't accept this. And that probably then would count as a dispute.
Thank you. The second point, which I think was an observation from Edward Brown, which I hope by pressing this button I can share with you all, which was in relation to your point about whether it was in the member's interest not to complain to the pensions ombudsman about the purported offset, and whether in that situation the trustees ought simply to impose the set-off anyway, taking the risk that the member might then complain to the pensions ombudsman themselves. And as Edward says, that might amount to a breach of section 91. But if the trustees could win before the pensions ombudsman, that might be a worthwhile risk. And a recollection that there may have been a case before the ombudsman a few years ago where the consequence for that breach was a fine of a maladministration payment rather of £250. But nevertheless, an order allowing recovery, which of course, if the sum is of anything in the region of thousands of pounds or more, becomes a risk worth running. So it's a useful observation.
Simon, do you want to say anything about that? I've got a couple of thoughts about it.
No, I think, well, there could be some, the trustees could come in for some criticism, I suppose, down the line doing that. It's maybe the trustees take the view that it's worth the risk and they can live with any criticism in front of the pensions ombudsman. But if it went higher on an appeal, then there could be quite significant adverse publicity for the trustees. But I mean, it may well be a question of risk reward, but it is risky, I think. Yeah, well, I tend to agree with that, and I think the fact that it's being suggested a trustee should deliberately breach section 91 to provoke a member into the catastrophic error of complaining to the pensions ombudsman, which then allows the ombudsman to order the recovery of time-barred overpayments, suggests to me something has gone wrong in the ombudsman's analysis here. I think it's very curious that the ombudsman permits recovery of time-barred overpayments, which couldn't be recovered in court, which goes against the sort of one of the founding principles, which is the ombudsman shouldn't be able to do something a court shouldn't do. But anyway, it's a very interesting observation, but I think I will hand back to Emily now for the next talk.
Yes, thank you very much. We've had a couple of additional comments and questions come in, but what I suggest we do is we pick those up at the end, just to give us time to listen to Andrew and Tom now on their discussion about limitation periods, and then we'll pick up that additional point at the end. So over to you, Andrew and Tom.
Thank you very much, Emily. Good morning, everyone, and may I extend my own warm welcome to you all. Tom and I are going to talk about some limitation issues that arise in relation to claims for pension underpayments. When the idea for this talk was conceived, it was confidently expected that judgment in the Axminster case would have been delivered in advance of today. However, that wishful thinking has not been rewarded, and we still await judgment in Axminster being handed down. The practical upshot is that I have a considerably easier job than Tom, because my part of the talk is to discuss limitation aspects of the Lloyds case, in which judgment has been handed down. In fact, as many of you will know, there have been 2 Lloyds judgments that touch on limitation. Poor Tom will then be left to address Axminster in the second part of the talk. Fortunately though, Tom was part of the counsel team for the claimant in Axminster, so he is well placed to discuss the issues and arguments that arose. These 2 cases go rather well together because in Axminster, some of the limitation points raised in Lloyds were revisited. And to add an additional connection or some extra spice, the judge in both cases was the same, Mr. Justice Morgan. And in some respects, he was asked in Axminster to depart from his own reasoning in Lloyds, always a slightly sensitive exercise. We'll have to wait to see whether the judge was persuaded to change his mind, but as things stand, this is an interesting area because the law is not fully settled. What I plan to do initially, by way of an appetizer to Tom's main course, is to explain the approach taken in the Lloyds decision towards some of the limitation issues, which then featured in Axminster. As I'm sure you all know, the Lloyds litigation was concerned with GMP equalisation. The first judgment, which dealt primarily with questions of liability and methodology, was handed down in October 2018. One of the additional issues addressed in that judgment related to arrears of pension payments or back payments, where pension had been underpaid because it had not included an equalisation adjustment. It was argued that in the context of equalisation, the trustee had a limitation defence to a claim for back payments on account of section 134 of the Equality Act. In short, that section provides that where there has been a breach of an equality rule, arrears of benefit can't be claimed going back more than 6 years. On the face of it, that provision, therefore, seemed to provide a fairly straightforward answer to this particular limitation point. However, during the course of the Lloyds hearing, which lasted some 10 days, the representative beneficiary, or Rep Ben for short, raised a new argument, contending that section 134 was ineffective because it infringed the European law principle of equivalence. That principle requires that a claim to a remedy for breach of a right conferred by European law, which would encompass a claim for equalisation, is to be treated no less favourably than a similar domestic claim would be treated. And it was argued that a similar domestic claim for pension underpayment in a non-equalisation context would not be subject to any limitation period, and thus the 6-year period under section 134 infringed the principle of equivalence. Now, to make good that argument, it had to be established that a claim by a member of a pension scheme for arrears of pension fell within section 21(1)(b) of the Limitation Act, so that no limitation period applied. In Lloyds, the bank was allocated the role of arguing that a 6-year limitation period did apply and was supported on this point by the Crown. No doubt the Crown didn't want primary legislation to be declared ineffective. So the critical question, therefore, was whether a claim for a back payment fell within the key wording under section 21(1)(b). And if I could ask the next slide, Tom, you'll see that the key wording, we've highlighted it, but it's really an action by a beneficiary to recover from the trustee trust property in the possession of the trustee. Now, this was not an easy issue for the judge to decide. It raised a novel point on which there was no directly relevant authority. Further, it's clear that section 21 was not drafted with the problems that occupational pension schemes may give rise to in mind. Indeed, at the date of the enactment of the Trustee Act 1888, in which the original predecessor provision to section 21 is to be found, the modern occupational pension scheme didn't even exist. And therefore, the judge was forced to grapple with the application of a statute designed principally to deal with private trusts to the quite different situation of a claim by a member of an occupational pension scheme. In his 2018 judgment, the judge dealt with this limitation issue in a fairly summary fashion. That no doubt reflected the manner in which the argument had arisen, and that it was towards the end of a long hearing and also a long judgment. In brief, the judge considered that the wording of section 21(1)(b) should not be construed narrowly, and that where the trustee has retained assets which are subject to the trust, and out of which the trustee is obliged to make the payment to the beneficiary, section 21(1)(b) applied. And so the judge concluded that there was no limitation period in respect to the claim for a back payment. Of interest, the judge considered but dismissed two particular points made by the bank. First, the bank pointed to the fact that a member who has been underpaid does not have a proprietary claim to any specific asset in the possession of the trustee, and thus it was said that a claim for arrears is not a claim to recover trust property. In response to this, the judge didn't think that it mattered whether or not the claim was a proprietary claim in respect of specific property. He nonetheless thought that such a claim fell within the wording of the provision. Second, the bank argued that the Rep Ben's approach was wrong in principle because, for example, a scheme in deficit may not have assets with which to satisfy a claim other than the ability to call on the employer to fund the scheme. Accordingly, if the Rep Ben was right, the correct limitation period may turn on the state of funding of the scheme at any point in time. However, the judge dismissed the relevance of this oddity on the basis that it did not apply to the facts of the case before him. As mentioned earlier, the judge was unable to gain a great deal of assistance from the authorities because there was nothing directly on point. However, he considered that his construction of 21(1)b was supported by two cases, a 19th century case called Howe and Earl Winterton and a recent Supreme Court case called Burnden, Holdings and Fielding. That approach was a little curious because these were not cases in which the Rep Ben had actually placed much or any weight at the hearing. I know that Tom is going to say something about the relevance of these two cases in a few minutes, so I won't say any more about them at this stage. Therefore, the upshot was that the judge concluded there was no limitation period in respect of a domestic claim for pension arrears, and having rejected some further arguments about the principle of equivalence, he held that section 134 was ineffective. So, quite a bold decision from the judge. As some of you may be aware, the practical importance of this limitation outcome was reduced in the Lloyds case because of the judge's decision that the forfeiture rules under the Lloyds schemes were applicable to forfeit underpaid instalments of pension that were more than 6 years old. Section 21(1)b was again considered in the most recent Lloyds judgment handed down towards the end of last year, which dealt with undercalculated pension transfers. Where a statutory transfer has been made, but the amount paid failed to take account of an equalisation adjustment, the court, Mr. Justice Morgan again, held that the trustee is obliged to make a top-up payment to the receiving scheme. The issue then arose whether a member's right to require the trustee to make a top-up payment to the receiving scheme also fell within section 21(1)b, and therefore no limitation period applied. In other words, could it really be said that a claim for a payment to be made to a third party fell within the language of recover from the trustee trust property? In answering this point, the judge thought it was clear that the word recover, as used throughout the Limitation Act more generally, is not restricted to a case where the claimant was, at an earlier point in time, in possession of the relevant property, had lost it, and was now seeking to regain possession or to recover it. So, for example, the statute frequently refers to an action to recover damages, yet those damages will not previously have been in the possession of the claimant. Of course, the usual case in which the term recover is used would still involve a payment being made to the claimant rather than a payment to a third party. However, the judge considered that although that might be the usual case, the language of section 21(1)b did not preclude recovery by means of payment to a third party. Importantly, in his view, as you can see from the slide, section 21(1)b is not limited by inclusion of, for example, the words recovery by the claimant. The judge also thought that this extended meaning, so as to apply to a payment to a third party, accorded with what he considered to be the policy behind the statutory provision, which was to enable a beneficiary to enforce the performance of a trust where the trustee remained in possession of the trust fund. And therefore, the judge held that section 21(1)b also applied to top-up payments. I would just make a couple of comments in relation to the relevant policy, and these comments apply to the judge's decision on section 21(1)b more generally, including in his 2018 judgment. The relevant general policy behind the Limitation Act is to restrict the category of claims to which no limitation period would apply, and thus to discourage the bringing of stale claims. Accordingly, it might be said to be contrary to this policy to give an extended meaning to the verb recover and thereby enlarge the circumstances in which no limitation period applies. Further, the exception to that general policy, which is manifested in section 21(1), is to disapply a limitation period where either the trustee has acted fraudulently or the trustee would derive a personal benefit from a breach, i.e. by retaining trust property for himself or herself. Whereas neither of these situations arises in the case of pension underpayments. So it is debatable whether the judge's decision was in fact supported by the policy behind the provisions. So that is how section 21(1)b was dealt with by Mr. Justice Morgan in Lloyds. I'll hand over now to Tom to discuss how various limitation issues arose in Axminster.
Thank you very much, Andrew. as Andrew identified, I'm going to need some help here. So, Harry, could you show the first poll, please? Have you ever given a talk about a judgment without the judgment? And please feel free, if you're able to, either click yes or no, or yes, but I'm not prepared to admit to that. And can we have some results of that? Okay, I'm going to need the particular help from the 7% of you, because we do not have judgment in Axminster, and the title of this talk is Limitation Following Axminster. Second poll then. Would you advise, once you've got the questions, that I make up the outcome and the reasoning, that I talk about something completely different and hope no one notices, bluff for a while and hope the judgment's delivered in the meantime, or answer 4, keep asking these poll questions until time runs out? Any thoughts would be extremely welcome. Obviously not from Andrew. Harry, do we have any results? It's going to help me. Okay, mixed spread. Looks like I should just make it up. Well, that accords nicely with what I was planning. Third question then. Would you like, so this is real audience interaction. Would you like me to summarize the key arguments that were run, or to say something about deliberate concealment in the Limitation Act, which arose as an issue in our case, didn't need to be decided? Thirdly, a bit of both. Fourthly, anything as long as it's quick. And again, any help other than from Andrew would be extremely gratefully received. Fantastic. Thank you, 59%. I understand the 10%. Right, a bit of both. Let's do that. The case is called Punter Southall Governance Services Limited against Hazlitt, but it's about the Axminster Carpets Group pension scheme, or retirement benefits plan. So it's known as Axminster. And one of the issues we argued is whether a claim by a member of a trust-based pension scheme for arrears of pension was subject to any limitation period under the 1980 Act. So as Andrew says, it's the same issue that was considered in Lloyds 1, and we appeared in front of the same judge. The issue arose because, unsurprisingly, a number of deeds and instruments dating back to 1983 dealt with rates of annual increase on pensions. So it wasn't about GMP particularly, this was about annual increase rates. And there was uncertainty as to both the meaning and the effect of those, so that as the case developed, it was unclear whether members were entitled to arrears of pension increases, although there were two separate categories of arrears that arose as well. One was GMP and one was delays equalising normal pension dates. So we had sort of 3 categories of arrears. And although a compromise dealt with some of the principal issues of what sums were due, it left open the question of whether claims to arrears that were more than 6 years old were time barred. So we asked Mr. Justice Morgan to look afresh at the issue that he decided in Lloyds 1, with the benefit of fuller submissions and rather more case law, and he agreed to do that. And as Andrew identified, I was part of the claimant team, the representative defendant in that case, represented by Andrew Short and Stephen Butler, and I was led by Henry Legg. We really resolved the issue in our minds down to one of statutory construction, unsurprisingly. Both parties agreed, if you look at the slide, that a claim by a member of a trust-based pension scheme for arrears was a claim in respect of breach of trust. The defendant argued that it was also to be described as a claim to recover trust property, but you start the analysis by saying it's a claim in breach of trust. And that means it falls within 21.3 and has a 6-year limitation period, unless it also falls within 21.1. So that's why the opening words of 21.1 are important, because there is a period of limitation prescribed by this Act for claims in breach of trust, and it's 6 years. So the focus then shifts to 21.1, and in particular 21.1b. And the rival contentions, we said that the words "to recover from the trustee trust property in the possession of the trustee" meant the action by the beneficiary was an action to recover property to which the beneficiary had a pre-existing proprietary right, not just claiming an asset that happened to be held on trust. And that was the big dividing line. Now, as Andrew's identified in Lloyds 1, the conclusion was no, claims for GMP arrears are not covered by limitation. They do fall within 21(1)(b). And the two cases that the judge relied on for that conclusion, Howe and Earl Winterton and Burnden, are ones where we started the argument by saying they don't really help. Howe was a case to do with trying to recover money back into a trust fund. So it was a claim against the trustee requiring him to pay money back in following a breach of trust in not accumulating rents. And we said that's rather different to a member's claim to require money to be paid out of the trust fund. So that was why we said Howe didn't really help. Burnden, yes, it included a claim for equitable compensation for breach of fiduciary duty, but the relevant breach was misappropriation of a particular piece of property, which was a share. And both the Court of Appeal and Supreme Court, while holding that a claim for equitable compensation fell within 21(1)(b), we said they're not holding that all claims for equitable compensation fall within that. We said they were limiting the approach to claims relating to an interest in a particular piece of property. And so we said that didn't really advance the argument either. And we discussed a lot of other cases. The judge remarked in argument that we'd really gone, or both sides had gone to the cupboard marked helpful authorities and found it was bare. There were then a number of examples to try and test the rival interpretations. We said, for example, assume the trustee has £1 million of trust property, is faced with beneficiary claims of 500,000. So on that basis, if the other side are right, certainly the claims aren't time barred. They are recovering from the trustee trust property. Suppose then some more claims come out of the woodwork, taking the total claims up to 1.5 million. So suddenly then at least 500,000 of those claims are barred. Suppose then, as time passes, more money comes into the trust fund, employer pays in, something happens. Does somehow limitation fall away again? Do you resuscitate a limitation period once the money goes down? We were saying that really the other side's argument was putting quite a lot of strain and quite an impractical outcome on these words. But the punchline is one that I can't deliver, and we will have to wait and see what Mr. Justice Morgan made of all these. He listened very carefully, and we had a lot of time and a lot of argument, and he did seem open, certainly, to hearing the issue afresh. So look out for it, and as I say, it really resolved to testing rival interpretations of the words you see on the slide. The second issue that I wanted to briefly cover was Section 32, because as a fallback, the defendant in our case said if he lost on 21(1)(b) and the claims were time barred, then for certain members, limitation was postponed because the trustees had deliberately committed a breach of trust by underpaying benefits. And the facts were important, obviously, because in our case, the trustees had taken advice as to the meaning and effect of the plan's governing documents. And they were told that the increased practice didn't match the legal position, albeit there was some uncertainty. And they were told members weren't receiving their entitlements, and continuing this would represent a breach of trust. They were advised to obtain informed consent, and did so from some members, but not from others. And in the conclusion of that process, there's a record that the trustees' view was that they had accorded, or their continuation of ongoing practice and what was actually being done accorded with what had been the intention with when the relevant documents were entered into. Now, Section 32 deals with, I can get the slide on, which I can't. There we are. Deals with postponing limitation periods, as Simon says, in cases of fraud, concealment, or mistake. And the focus here was B, deliberate concealment, and in particular it's 32.2, deliberate commission of a breach of duty in circumstances in which it's unlikely to be discovered for some time. Well, pension scheme trustees taking decisions that affect members are likely to be taking those decisions in circumstances where it's unlikely to discover that they'll be discovered for some time, because members don't really know how members' entitlements are being worked out, paid. So you're likely to find that if there has been a breach of duty by a trustee, a member won't find out about it for a long time. But the focus then becomes, what does it mean to talk about deliberate commission of a breach of duty? You might have thought that trustees who receive advice that entitlements are uncertain and continue their current practice despite advice they're acting in breach of trust, would be reckless. But if their view is the entitlements are those that were intended, can you really say that they intend to act in breach of trust, or no, they're doing so? So what does deliberate mean? And the answer comes from a case earlier this year, Canada Square Operations and Potter. It's a case in the Consumer Credit Act sphere. And unlike some earlier cases, including one from the House of Lords, this resolves the question in favour of simply a recklessness test. So if your trustees, you don't need to show that they actually positively intended to act in breach of trust or knew they were doing so. It's enough that they knew there was a risk they were committing a breach of duty, and in circumstances that were known to them, it was objectively unreasonable to take that risk, but they continued regardless. That is enough. So a recklessness test now applies. Now, the case is probably going to go up to the Supreme Court. As I say, it seems to conflict with the House of Lords authority, and the sum at stake is so small that it's pretty clear it only went to the Court of Appeal in order to get some certainty on the point. So we need to watch this space. But at the moment, it's quite a striking proposition for those of us advising trustees that advice you may be acting in breach of trust, or indeed breach of contract or any other breach of duty, which is given in circumstances where the breach itself is unlikely to be discovered for some time, might mean that those taking the decisions thereafter can't rely on a limitation defence. So that's what I wanted to say under 32. I will, I think, pause there and hand back to Emily. Thank you.
Thank you very much, Tom and Andrew. I think, having a look at the questions at the moment, they are directed to the points that Edward and Simon were talking about. But I did have one question, Tom, just about the point you were touching on then about deliberate concealment, that struck me as having significant ramifications for trustees considering whether or not to apply for Part 8 directions. And it may motivate them to be even more conservative and to be inclined to apply for relief in that respect because they're concerned otherwise about an allegation of deliberate concealment.
Exactly right. If you're advised there's an uncertain position, it becomes even more dangerous, I think, to carry on regardless, particularly when there is the option of going to the court. So yeah, I think that is a takeaway point.
Two questions filtered through just in relation to Section 32, just while we were speaking there. The first from Kate Lloyd. In Axminster, does the fact that they tried to get informed consent mean that Section 32.2 wouldn't apply?
They didn't try to get informed consent from all members, and the 32.2 argument relates to those members they didn't try to get the informed consent from. So it wouldn't have been an answer.
And Catherine McAllister asks, in Axminster, did they consider whether the forfeiture rules should apply? Yes,
they did consider that. So there will be some consideration of forfeiture as well in the judgment. Yeah.
Thank you. Going back then just for the moment to what Edward and Simon were talking about earlier, we had a couple of questions come in during the course of that talk which we didn't have time for in the interim period, so I thought I'd just touch on those now. The first one from an anonymous writer in relation to the question of the member sitting tight to wait to see whether the trustee would bring a claim to court. The question there was, why wouldn't the trustee simply recoup overpayments using the equitable recoupment route and then recover overpayments that way? Does the member sitting tight achieve anything? I don't know whether Edward or Simon had any thoughts about that.
Well, I think that that's related to the point in Edward Brown's earlier question, which is that if the member sits tight and the trustee has any interest in obeying the law, the trustee shouldn't make a deduction because Section 91 says that they shouldn't. At least for time-barred overpayments where you need a court order. But I can see that might yield to the interests of practicality.
Thank you very much, Edward. We had two related questions concerning the duty versus the discretion to recover overpayments. The first from Aaron Dunning-Foreman, who asks, considering the distinction between a duty to recover versus a discretion, do we end up in the same place, even if it is a duty, by saying that the trustee's duty to recover is subject to the usual principle of proportionality, which gives the trustee scope not to seek recovery in that case?
Well, yes, I think it may tend to collapse into a single issue. I mean, it seems to me that overpayments that one can go that far, but whether it then goes recover, I think it is whether one casts as a duty subject to proportionality or simply a discretion in the exercise of their powers, administrative powers as trustee. It seems to me one get to the same point. It seems to me probably the correct analysis. They're under duty to consider whether to recover the overpayments, and then have a discretion as to whether to do so or not. Although that is subject to the point that Edward raised earlier regarding whether it's essentially you're paying benefits twice over on the equitable recoupments of analysis, and that would be a breach of trust. So maybe it does go further, and maybe it should be a duty. But I think I prefer the former analysis myself.
Thank you very much, Simon. I have kindly been prompted as to the time, and I'm conscious that our 1 hour session has overrun, and also that many of you now have to get on to other commitments. We've got a couple of other points which cropped up, which I suggest that Edward and Simon might be able to pick up at the end. But what I wanted to suggest now is for the rest of the participants, thank you so much for attending, and thank you also to all of our speakers today. We are very grateful for you attending, and we are very interested in your feedback. So I understand that a short questionnaire is going to crop up in your browser at the end of this session. We'd be very grateful for any comments you might have or any topics that you'd like to hear from us in the future. I understand that this webinar has been recorded, and that recording will be on our YouTube channel, which apparently you can find by typing in Wilberforce Chambers into YouTube. And as I mentioned at the very start of this is the first in a series of 4 lectures this year. There are 3 more to come, the first of which will be next Wednesday at 11 AM, where we are delighted to be joined by Gary Squires from Lincoln Pensions, and he is going to be talking with Mike Tennant QC about DB pensions and corporate insolvency. I'm hopeful that you've got the details of that, but if not, I'm told that you can contact seminars@wilberforce.co.uk and further information will be provided. Thank you so much for everybody attending today. If they have the opportunity, Simon and Edward might be able to stay on for a couple of minutes just to answer the remaining questions, but I understand that Andrew and Tom may need to go. So thank you so much.
Thanks everyone for joining.
Thank you everyone. Bye-bye.